People just don't get intellectual property, or IP law. Now, I'm not an attorney who's argued any big copyright cases before a federal jury, and I'm not even eligible for the patent bar, which is another thing I realize I should probably explain but don't have time to. Long story short, I studied IP law in law school, but I'm not an authority on the subject, and I can't give you legal advice about it. Ever. Especially you, Kevin. If you're trying to find legal advice from strangers on the internet without knowing their names or where they're licensed, I have some friendly, non-legal advice for you. Please don't. That's, probably not going to get you great results. But back on point, I have a purely academic interest in IP law and wanted to make a quick primer that I could point people to whenever I see someone talk about copyrighting the color blue or how they're patenting their cool story ideas. So, let's do this thing. What do you need to know out of this old thing? Under U.S. law, a copyright is, quote, a set of exclusive rights in any original works of authorship fixed in any tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device, end quote. We won't worry too much about what those exclusive rights are today, but they can be broadly summarized as the right to produce, license, and sell copies or performances of that work, and any derivative works such as sequels, or stage, movie, and comic book adaptations. Derivative works, forget I said anything. It's way too complicated for right now. For now, it's sufficient to say that under current U.S. law, a copyright is the right to copy and license copies of any sufficiently original creation that is written down or otherwise fixed in some real, tangible way, like a book. Essentially, the creator of any copyrightable work creates both the work and the copyright in that work at the same time, and they own the rights in that work unless and until they sell or disown that right. They don't own the ideas expressed in that work, which is why Twilight's writer can't be sued by Anne Rice for using the idea of romantic, brooding vampires. We could spend weeks talking about specific applications and exceptions to these rules, which is how lawyers get paid, but I'm not getting paid for this, so let's move on. Next, it's worth taking a quick look at patents. Patents can be granted to protect sufficiently original methods, processes, or machines, or, quote, composition of matter or any new and useful improvement thereof, end quote. We usually refer to patents and copyrights as providing a legal monopoly on the works, and patent rights basically allow patent holders to sue anyone who uses the patented method without the patent holder's permission. Now we can start talking... No, forget you saw that. That's from a different video. Sorry. As you might be able to guess, there is some overlap between patentable and copyrightable works, especially in the realm of computer programming. Particularly novel computer programs tend to enjoy both copyright and patent protection. But unlike copyrights, which exist as soon as the copyrighted work exists, patent rights don't exist unless the patented thing is registered with the United States Patent and Trademark Office, or USPTO. Patent protection is also narrower in scope and doesn't last as long as copyright protection. After a patent or copyright expires, the copyrighted or patented work is no longer protected and becomes a public domain work, which means that any member of the public can use or copy that. Therefore, a lot of people prefer copyright protection to patent protection for a work that might qualify for both, to avoid complicated litigation about how much of that work was covered by patent law and not copyright law. So we can see there's already some cause for confusion over whether something is copyrightable or patentable. But here's where things get really confusing for some people. Now, we get to talk about trademarks. Trademarks are actually a mechanism to prevent unfair trade practices, and aren't, strictly speaking, intellectual property. Think of trademarks as a way to distinguish and protect your brand. Almost anything can become a trademark if you can prove that consumers identify your particular brand with that thing. So, smells can be a trademark of a cell phone store. Color combinations can signal whether your delivery is from UPS, FedEx, or DHL. And the word Sekiro can tell consumers that a game is made by From Software. It may sound broad to let UPS own the combination of brown and gold, but again, remember, this is not a property right. What FedEx has registered as its trademark, or trade dress, same thing, is the use of a particular shade of brown and gold on delivery trucks and the uniforms of its employees. So DHL can't confuse consumers by sending out a bunch of brown uniformed goons in brown trucks to terrorize the neighborhood and drum up a bad rap for UPS. Or was that FedEx? Although, now that I think of it, if we start having delivery service turf wars, trademark issues are probably going to be pretty low on our priority list. Like patents, trademarks must be registered in the US. Well, okay. Law is complicated, always, and it's not as simple as that. In order to enforce a trademark nationwide across the US, it must be registered with the USPTO. However, there are smaller, more local trademarks that can be created without registration. Trademarks used to be intensely local, intensely constrained to a small geographic area, and historically, therefore, you wouldn't need to register them. But in the modern trademark regime, you are strongly encouraged to register them. So, like patents, trademarks should be registered in the US and can be disqualified for being too generic. You can't, for example, trademark the word tissue to sell tissues with because that's literally just a description of the good. Therefore, the more arbitrary or unrelated a proposed trademark is from its product, the less the product relies on that trademark, the more likely it will be allowed as a trademark, so long as it's actually used by consumers to identify the brand. A great, perfectly eligible trademark would be using the word Totino's for your branded pizza rolls. It's completely arbitrary. But you probably wouldn't be able to trademark the term frozen pizza-like dough pocket, because that's an actual description of the goods. Now, while courts have tried to prevent trademark from overlapping with copyright or patent laws, there's always a little bleed over. For example, the Southern District of New York found defendants had committed both copyright and trademark infringement where they sold bootleg Barney the Dinosaur costumes. That was back in a 1999 decision, which I'll provide the citation to in the description. So, it's rare, but it is technically possible to commit trademark, patent, and copyright infringement all at once. U.S. patents last at most 20 years. U.S. copyrights currently last either 120 years if the creator was a corporation or other legal entity, or the life of the human author plus 70 years. And that's pretty much it. This is just distinguishing the three types of commonly understood intellectual property, and isn't an in-depth exploration of any of these concepts. So what's got my knickers in a bundle, you might ask, if you were Dick Van Dyke and Mary Poppins? I'm sorry about that. Well, I saw a headline that looked like this, which took me to a story that was actually pretty interesting. Someone with common misconceptions regarding trademark and copyright can look at this headline and think, "Oh, Banksy, you silly wanker. Of course you can't maintain a trademark if you think copyrights are for losers." But all of you who've watched this video should now be thinking, huh? What? What do copyrights have to do with trademarks here? Am I all right? Am I having a stroke? Well, first off, if you're smelling burnt toast, go check the toaster. Then maybe check in with a medical professional. But secondly, you're right. Saying copyrights are for losers shouldn't preclude you from getting a trademark in something. It turns out that the European Trademark Board noted that Banksy's behavior, refusing to use their supposed trademark in commerce, not only disqualified them from enforcing a trademark, but also suggested that they were using a shell corporation in trademark registration to protect against copying of their work, which is the domain of copyright protection, while they also refused to establish copyright ownership of their own work under their own name. While Banksy's works are indisputably copyrightable and copyrighted, they have essentially disowned their copyrights by refusing to publicly name themselves, and would have to reveal their true identity to successfully sue anyone for copyright infringement. Well, except that it seems like he could assign his copyright to another shell corporation and force them to sign a non-disclosure agreement, but Even then, to enforce their right, the shell corporation would need to prove who made the art and how this corporation obtained the copyright. And of course, that would become part of the public record, potentially exposing Banksy's real identity. There's a lot of nuanced issues for Banksy to consider, regardless of how he feels about the whole system. Now, isn't that a lot more interesting than just thinking that trademarks and copyrights are the same thing? Thanks for joining me for this one. It's supposed to be another quickie, which I, of course, took way too long to do. I'm trying to change things up a little bit with the format of the presentation. You guys made me wear a suit for this, because you have to wear a suit when you're talking about the law. That's just, the law, I think. I hope this clears up a lot of confusion. It probably creates a lot more confusion, because that's the tricky part about the law, is there's always more questions. Don't mind any neighbor noise. I'm working with limited space here. This is my apartment, so I don't have sound dampening equipment. I have a shitty lapel mic, and that's about it for up here. So thanks for watching again. Click like and subscribe if you'd like to, or don't, I guess. That's fine.